Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. The First Amendment is just an interesting amendment with many fascinating applications, especially during these times. There are so many court cases that interpret this one short amendment, but I want you to know all explanations here are my own and are not to be ascribed to my school or my students. For informational purposes, I'm a professor at Mississippi College School of Law, and I've been a professor for about 30 years. Let's get right to it. We've started with the general rule. Pure speech is protected from content regulation by the government, unless the speech fits in an unprotected category. And we have considered 4 traditional unprotected categories: speech that advocates illegal action, fighting words, defamation, and obscenity. And you can go back and look at the clips and consider the notes about those 4 categories. The court has said there is some speech that has slight value, but can cause great harm, and government has the right to regulate it with a low level of review, not with strict scrutiny, but a low level rational basis. But the question that has come up several times is whether additional unprotected categories ought to be added. So this clip is just a brief introduction to these cases that considered that question that my students are going to do all the reading for our next class meeting. This will be just a brief introduction for my students and just a brief summary for you, for the rest of you. I've indicated the names of the cases in the text box, and you can go back and read more for your own learning on your own, or Google them. So let's see, what categories ought to be added that the court has considered. So remember when we talked about obscenity. Obscenity is unprotected speech that the government may regulate with a low level of review. However, there is a test for Miller. Remember, there are several different requirements that must be met for the test to be, for the material to be deemed obscene under Miller. And one test is whether the work taken as a whole lacks any serious literary, artistic, scientific, and other value. Now, the first case we're going to talk about relates to this test, Miller test, and the case is called New York versus Ferber. New York versus Ferber was about a law banning certain sexual depictions of children, even if the material was not obscene under Miller. Sexual depictions of children, even if not obscene under Miller. So the court said, yes, the government can ban that material. The court talked about the need to eliminate child pornography, period. The need to dry up that market in child pornography, and also the need to protect children, as this material would pose a permanent record of the abuse of children, and also just to protect children more. So the Ferber test was added. Certain sexual depictions of children, even if they do not satisfy Miller, are unprotected, and the government may regulate it more. So after the Ferber case, we had 2 other related cases. And the next one is called American Booksellers. I've given the whole name at the bottom, American Booksellers. Now, this was the argument. The argument was that certain pornography about women may not be obscene under the Miller test. However, the material may cause great harm to women because it discriminates against women, subjugates women, shows the torture or humiliation of women. So even if the material does not meet the obscenity test under Miller, the law said that material should be deemed to be unprotected and government can regulate it. Now, the court had already done something similar in Ferber to protect children, but the court refused to extend this protection to women. The court said, no, the Miller test will be the test. We're not going to carve out an additional test, according to the court, for materials that may subordinate or cause harm to women. Now, the court said, the opinion is very interesting. The court said, yes, this material may lead to the harm of women. Yes, this material may lead to the continued discrimination against women. But the court declined to create an additional unprotected category. So if there is material that subordinates, subjugates women, the court said, Miller is it. We're not going to carve out an additional test for a more unprotected speech. So far, Ferber is the only additional one added. But then there was another case that also related back to Ferber. And this case is called, I'm looking for my notes, it's called Ashcroft. And in that case, in Ashcroft versus Free Speech Coalition, excuse me, and I have the date for the case and the name in the text box, so you can Google and read about it. So this is the issue. So now that we have the all of the internet, all of the electronic communications, there was a law that said, okay, there may be some depictions that look like children, but they are not really children. They may be adults pretending to be children, or they may be computer-generated models of children engaging in sexual conduct. So the argument was this should be unprotected too, because if you have representations that look like children, that too may add to a child pornography market, or to some individuals' desire to see this material, which could result in the harm to children. But the court said, no. The court actually said, not yet. In other words, the court said, no, these are not real children. But then several justices added a caveat. Several justices said that one day, with technology, these computer-generated models may look identical to children. It may be hard to distinguish them from children. And then in that instance, there may be a need to say that it's unprotected speech that government may regulate more freely in order to protect actual children from abuse and also to protect society. But as of that date, and Ashcroft was decided in, I'm looking at my notes, Ashcroft was decided, I believe it was in 2002, the court said the court did not add an additional category of unprotected speech, of depictions that look like children, were generated to seem like children, but were not actual children. So far, the only additional category added to unprotected speech was the material at issue in the Ferber case. Okay, I got a few more for you. So then there was an argument and a case. What about videos that showed animal abuse? What about, have you heard of crush videos? And in crush videos, you may have a small animal like a kitten maybe, and then there's appearance of a female leg in high heels that crushes the animal in pain or to its death. That's why they're called crush videos. So there was a law to have this material out loud, to have this material unprotected speech, videos that promoted or showed animal abuse or animal cruelty. And the court said, the court did not add that as an unprotected category. The opinion is lengthy, and I'm sure my students will explain it all to me in class later this week. But the court seemed to talk a lot about hunting. And it said there are some hunting videos that teach people hunting techniques. And the court talked about the difficulty to distinguish hunting videos, which it wanted to allow, from these crush videos. So in conclusion, the court declined. The court said that it was not adding another unprotected category of videos that depict animal cruelty. It doesn't end there. What about violent video games? Violent video games to be sold freely to minors or to young people under the age of 17. The case was Brown versus Entertainment Merchants. And basically the court again declined. It's some really interesting language where the court talked about the right of merchants to be able to sort of approach children to sell this material to them. But there's also an interesting dissent. One justice disagreed. One justice said this should be unprotected speech, violent video games sold to children. And that justice said, something is wrong here. A 13-year-old cannot go into a store. They say a 13-year-old boy cannot go into a store and buy a magazine with nude women. But the same 13-year-old child can go and buy a violent video game that models a woman being tortured or sexually assaulted. And the justice says something is wrong here. All of that should be unprotected speech, especially the marketing of this material to young people. What do you think? Should the court have agreed with the dissent and carved out that additional unprotected category? Okay, let me give you another one. Now, what if a person tells a lie and says they have military valor, military medals, military successes, and they do not have any. Can they be punished for that? Is that unprotected speech? Now, a case that was much talked about is called U.S. v. Alvarez from 2012. And the court said they are not going to make it unprotected. They're not going to carve out an additional unprotected category of people who lie about military valor or military medals. The court said it may be different, though, if the lie is told in order to get some monetary award or for some pecuniary benefit. Then the court said that could be a different situation. But a lie about a military valor, the court said, is not in a category of unprotected speech. So you see here, the court seems to be in the recent years, and I guess the last 15 years maybe or so, the court has been hesitant to add to the categories of unprotected speech that we have. Later, we're going to talk about burning of the American flag. Is that unprotected speech? And I think, as we know, the court said it is not. It is not in an unprotected category. We're going to look later at some other cases like about cross burning and what have you. Is that unprotected speech? So here, we know we have the 4 categories of unprotected speech, 4 plus 1, right? We have speech that advocates illegal action, fighting words, defamation, obscenity, and the court added the Ferber case if there are sexual depictions of children, even if they do not meet the Miller test, the government may still more freely regulate them in the unprotected category. For all of these others, the court was very hesitant to add more unprotected categories. What do you think? Of all of the unprotected categories we've talked about, which one do you think should be removed from the unprotected list? And of all of the cases I just ran through so quickly, which one do you think the court got wrong? The court got wrong and should have included with the unprotected speech. You know, what do I think? I'm asking you. Learning is so important. Learning about our Constitution. Check out some of those cases I've mentioned in the text box. Read them and think about it for yourself. Google these issues. Learning takes us on the path to enlightenment, and enlightenment to freedom, and freedom to justice, or at least to a taste of justice. Subscribe and sign up for notifications. You don't want to miss a thing. Thank you.